Subparto bonds, 1,500 when required in amount released. Drill deep in the cover, operated to own well, gas well with a bond with the amount provided in section of the submitted along with the application to drill the deep in the convert with the operator train for the production class 2 wells. The application was not an owner September 26th, 1991 of the right to produce well with a well transfer with the quest applicant with a non-permanent record on September 26, 1991. Applicant have the bond forfeited subject with the unimpeded with the unvaded with the Department of Final Administrative the decision requiring when the wells to be plugged. Applicant not sure of the assess of the annual well fee with the July 1st proceeding with the application of the applicant with a permanent record of the unplugged well official year with not subject to unimpeded until the Department of Final Administrative the decision. Applicant has the fund expended with the well plug within behalf of the department use of the funds of the PFR with the applicant is not appointed trustee with the receiver in accordance with section 240 1410A4. Bond is required with the file with the department to deepen convert and operate as well, Class 2 wells amount with the bond should be $1,500 well with a 2,000 feet deep, $300,000 with a well than 2,000 feet or more deep, $25,000 for up to 25 wells with a permit, $50,000 up to 50 wells with a permit, $100,000 for all wells with a permit. Failure to provide with a required bond with the issuing of the correct court resuscitation operation according to section 240-185B. Bond submitted in section 240-1500A with the shall be released and with all the wells converted with the plug and the restored in accordance with subpart K. All wells covered the bond and transferred in accordance with subpart N. Permit has passed an assessment with the department in accordance with section 1917, 2 consecutive years permitted not in the Violation Act to operate a liquefied oil waste transportation system. Amount of the bond required to file with the department to have the permit authorizing person to operate with the liquid oil waste system shall be $10,000 with the request of the permit for the release of the permit ceasing operation system permittee system that is not with the Violation Act. Drill a test well with the amount of the bond required with the file with the department before with the permit issue with the geological strength of the coal other mineral test hole well connection activity regulated with the department issue with the $2,500 blank with the bond and $25,000 all permits or bulletin requirements of some permit or shall know all the whole of the well drill with the acreage permitted of the bond under the Surface Land Conservation and the Reclamation Act, the Surface Coal Landing Conservation Reclamation Act. When requested permitted bonds shall be released of the holes and plugged with the restored in accordance with section 240-1260. Permit is not in violation of the act. Or definitions. Bonds means a surety bond or security in lieu of thereof. The surety bonds mean an indemnity agreement that certain payable to the department to exceed with the permanent principal of the supported plus guarantee corporation all other transaction surety issue with the surety bond that does not include a surplus insurance provided precluded a surplus line producer. See other security means that an indemnity of agreement some certainty executed permanent principal with the support with the deposit of the department and one more with the following irrevocable letter of credit of bank organized authorized transaction business Illinois payable in the department upon presentation, certificate of deposit withdrawing on the federal insured bank made payable or assigned with the department placed in its possession. Alright, bond requirements. Bond shall in the form such that the department pays of the Illinois Department of Natural Resources with the conditions generally. Each bond shall conform to the requirements act for those for the declared purpose of the bond is required. Bond shall remain in effect for the obligation given when the fact has safety to satisfy with the bond has been released for the department and active with the support. Surety bonds of the bond shall be signed with the permit if the principal good sufficient with the cooperative corporate surety authorized transaction business surety in Illinois. Each surety bond provided with the bond be canceled. Surety act accepted after the latest 90 days provided with the department. Such of the notice shall be served with the department in writing and registered with the certified name with the department Springfield office. Prior to expiration 90 days with the cancellation permit shall be delivered to the department. The replacement bond and such bond with not delivered all activity by the permanent bond cease at expiration of the 90 days prior with it. If licensed transact bill Illinois any surety of the bond filed with the department suspend with a revoke for the permanent 30 days of the receipt of the notice of the department. New substitution with the revised surety bond with the security is recovered with the subpart with the failure to permit with the substitution bond with the L curve. If it is permanent with the bond with the substitution until the substitution have been made. Other security requirements. Letter of credit subject to the following conditional letter may only be with the bank organized authorized business in the United States. The issuing bank does not have the official office of the Canada election of the Illinois confirming the bank designated authorized to accept the negotiate and pay with the letter of upon presentation to in the Illinois. Letter of credit irrevocable during the term letter of credit with the forfeited collect with the department if it not replace suitable bond later with the credit at least 30 days before the expiration date. Letter of credit is payable to the Department of the domain and the part of the full of the upon of the receipt of the Department of notice for the forfeiture in accordance with the 240-1530. Department of the notice acceptable letter of credit excess of the 10% of the issue of the bank total capital surplus action certified President Bank providing letter of credit evidence of the more recently quarterly call report provided with the Federal Deposit Insurance Corporation. Letter of credit should provide on face of the Department of lawful to sign with the attorney with the Department is and it's some of the two with the waive of the notice process. A prayer on behalf of the confess of the judgment against the issuing bank with any confirming bank in the event with a letter of the credit is just signed. A letter of credit should be deemed made San Diego County, Illinois, for purpose of the enforcement and even the action of the enforceable the courts of Illinois construed under the Illinois law. Certificate and deposit shall be the following conditions. The Department shall require certificate of deposits made payable to the assignment of the Department, both in writing upon the record of the bank issuing certificate issued by the Department shall note whether the bank's issuing certificate to waive all of the rights of set off liens against those certificates of the Department shall not accept an individual certificate deposit with except of the excess of the maximum insurable amount determined by the Federal Deposit Insurance Corporation, Federal Saving Loan Insurance Corporation. Interest accruing in the certifying of the deposit shall be the benefit of the permit except for the accrued interest of the shall be first applied with the prepayment penalty of certificate of deposit fortified with the department. Certified deposit with the negotiable interest shall be paid with the Department of Possession. Certified deposit is not with the negotiable interest of the withdrawn receipt with the endorsement of the permit should be placed in the Department of Possessions. Forfeiture of bonds of the permanent failure to comply with the Department order to apply to repair of the well, the resale of the well, and in 30 days issuing with the security with the contingency with the ground of bond forfeiture pursuant with Section 6 and 19.1 of this Act. Department sent of the written notification certified of the elders to request of the permanent server of the bond, if any of them with the determination forth of the bond pursuant with subsection 8 above. The Department may also surety undertake necessary plugging, replugging, repairs, restoration work site will be demonstrated to be able to complete the work site according to the requirements of the Act. No surety liability should be released until the successful completion of all of the plugging, replugging, the repair, and restoration ordered by the Department. In an event with a forfeiture of the bond is warranted at subsection 8, the Department shall forward with the permanent right with a hearing. Such hearing with a requested writing with a permanent 15-day with a bond forfeit the notification mail in accordance with subsection B with the permanent does not request a hearing within 15-day period. The Department shall issue the final administration the decision order forfeiting hearing requested permanent with a hearing shall be scheduled 15 days with a receipt with a request of a hearing shall be conducted by an impartial hearing when not employed by the Department. A bonding with a forfeiture hearing the Department shall present evidence supporting determination or subsection A of the Department shall present with evidence contesting the Department determination or subsection A of the hearing officer administer the oath of affirmation submitted some penal witnesses written printed material to compel attendance of the witness production of the material to compel the discovery to take evidence within 30 days of the close of the record with the bond forfeiture hearing with the hearing officer shall with the recommended findings of the fact with the recommendation conclusion law recommendation disposition of the case. The record shall review the administrator of the record contested in conjunction with the hearing officer the recommended facts of the recommended conclusion law recommendation of the disposition of the case. The record shall issue the Department's final administrative decision affirming vacating and modifying hearing officer decision. That completes Subpart O bonds.